Court does call the case of the people of the state versus Sherrone Moore. Counsel, state your opinions.
Good afternoon, Your Honor. Katie Rosmersky for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who is present in court. Please state your name for the court.
Sherrone Moore. Thank you. And date and time set for sentencing. And the parties, are they ready to proceed?
We are, Your Honor.
Yes, Your Honor, we're ready to proceed.
All righty. Whoever would like to go first? Do people have anything that they would like to say before I do impose? Not that you have to, but.
I appreciate that, Your Honor. I don't have much to say, except to underscore that we arrived here because these charges are ultimately what was supported by both the facts and the law. We appreciate the court's efforts in communicating with both sides. Your Honor, we trust this court's decision-making as it comes to imposing the sentence. And so I don't have anything to say in terms of what we want you to impose or what we expect for you to impose. I trust that. I do, however, feel that I would be remiss in my duty if I did not underscore for the court and for the record that there was a young woman that was deeply impacted by the defendant's choices on December 10th of last year. I just want to make sure that we state that for the record, and I am confident that Your Honor will take that into consideration to the extent that it is important and appropriate.
Right away, notice what the prosecutor is doing here. They're not demanding a specific punishment. They're emphasizing the impact on the victim and then leaving the sentence to the judge's discretion. That's often a strategic move in sentencing hearings. But here's the question. Should the emotional impact on a victim outweigh every other factor when deciding a sentence? Let me know what you think.
Necessary in imposing your sentence, and I appreciate that opportunity. Thank you.
Counsel?
Much.
Just so that we're clear on the record, you received a copy of the pre-sentence investigation and report.
I have. I will address that when I get to the podium.
All right, very good.
Good afternoon. Good afternoon. First and foremost, with regards to the pre-sentence investigation report that was submitted to me by your probation department, there are no additions, corrections, or deletions. There are a few things that I would like this court to know about Sherrone Moore. Sherrone Moore is the only child of immigrant parents who came to this country for a better life. He grew up in a home marked by uncertainty. His father, an Air Force serviceman, was deployed overseas for long stretches, leaving his mother to carry all the responsibilities at home. That shaped it. It taught him resilience, responsibility, and the importance of family. Sherrone didn't always fit in. He was bullied as a kid and often kept to himself. Sports changed that. It gave him confidence, direction, and ultimately a purpose. That purpose became coaching, not for attention or status, but to help young men grow on the field and off. He teaches that success comes from facing challenges head on and handling adversity the right way. I have come to know Sherrone over the last few months. I have seen how he responds when things are at their hardest. He has handled adversity with grace and with dignity. Since this incident, Sherrone is engaged in counseling, gained insight into his life, and developed tools to guide him forward. He has recentered himself around his family, and he has taken responsibility, expressing genuine remorse to those closest to him, the people most affected by his actions. Your Honor, this is a man who is not defined by this moment, but by how he has responded to it. For these reasons, I ask this court to grant a deferral and place Sherrone Moore on probation. It is an appropriate sentence given the nature of the offense and Sherrone Moore's lack of any prior criminal history. Thank you very much. Thank you.
Because there was a no contest plea, I just want to make sure for purposes of the record, Mr. Moore does not wish to address the court. Is that correct?
That is correct.
All right.
Yes. I apologize. He has a short statement to make to the court. Rich, you'll bring now.
I want to thank my beautiful wife, Kelly, for her support, her strength, and standing by me. I want to thank this court and its staff for their time and consideration. I'm grateful to my attorney, Ellen Michaels, for her guidance. I've taken this process very seriously and work closely with the probation department to prepare for today's sentencing. I'm ready to proceed. Thank you.
There was nothing additional from probation, is it?
That is correct.
Thank you, Mr. Laird. Before I impose the sentence in this case, I think that there are a few things from this court's perspective I think need to be pointed out of the purpose here of what the court's going to do and what the court's not going to do. I want to make it very clear that the morality of what transpired, that's not something for the court to decide. I am not passing judgment on that course of conduct. I may have my own views on that, but I'm not here to pass judgment on it. That's way above, frankly, my pay grade. At some point regarding the conduct that is not before this court, the morality of it and the like, and to ultimately be left to this defendant and his God to make that determination, as well as the grace and forgiveness that might be bestowed upon him if deserving by his wife. But the court is also not doing, and what is not my role here, not part of my bailiwick, and it seems to have been so pervasive in this case, is to put a thumb on the scale of what might be future litigation involving the University of Michigan. That is not the world or realm I'm operating in at this particular point in time, and not part of this judgment and what I end up with. I think it's also important to point out, because I don't look at the news very much, but in looking at how people may misinterpret what has occurred here, and I want and feel it necessary to make that clear. There are certainly those that believe that as the charges were initially filed, the 3 charges of home invasion, third, the stalking charge, and the entry without permission charge, that there's a view that they shouldn't have been filed. And then there's a view that, well, should have stuck with it. I will commend counsel on this case because I think they have both shown courage, but particularly I want to address the Washtenaw County Prosecutor's Office and their courage in doing what is right. The reality of this case is the people, if they had wanted to, I would imagine, could have just decided to proceed with this case and just let the chips fall where they may. I think, as Mr. Sminsky stated before, that is not their obligation. Their obligation is to do justice and to do what is right. The very beginning of this case, so that people can understand it, the facts as they knew them supported the filing of the charges. I've been fortunate or unfortunate in this case to be able to see a lot more than I would in a normal case. This having been a no contest plea and a lot of information being provided to this court to determine whether or not there was a factual basis.
This is where the case takes a dramatic turn. The judge is essentially explaining that criminal charges aren't frozen in time. As new evidence comes in, prosecutors have an ethical duty to reassess the case, even if that means abandoning serious charges. That's not weakness. That's how the justice system is supposed to work. But do you think the public always understands that distinction?
But I want to make it clear that when the charges were filed, they were appropriate. But as with any case, as more facts become known and as more things happen, the facts and the analysis change. Now, I don't say any of what I'm about to say to try to bash anybody or to do anything, but I say it for the purposes of so that people can understand what the prosecutor's office was looking at. They had filed these three charges. The first two, the first being the home invasion third, and then the stalking charge, with the belief that on the 8th of December, 2025, that Ms. Shiver had informed Mr. Moore that some way that she no longer wanted contact. Now, with that, certainly they may be able to proceed with if there's attempted contact or other things that can occur by Mr. Moore's conduct, that people may have been able to proceed with a stalking charge. Stop for a moment and just tell you that what is called a predicate offense or the underlying offense for the home invasion third, the misdemeanor, along with a home invasion or entering a home, that the stalking charge had to be maintained. But here's what the people found out. And I will say that when the police, Pittsfield Township, are interviewing and they're going through, they are, I watched, I don't know how many hours of video in this case. And I will tell you that they were not only professional, they attempted to try to get to the bottom of it. At some points, their efforts seemed thwarted. That's my view. And that they were trying to get answers to a lot of different things. But as it was presented to them and they ultimately presented to the prosecutor, on the 8th of December, Shiver had indicated in her own words to them that at, I believe she said 6 a.m., or I think she specified that at 6:10 a.m., had told him that there wasn't going to be any more contact. And then any contact or attempted contacts, anything along those lines, would then potentially constitute a stalking charge. When the police department asked for Miss Shriver's phone, and I'm not saying that this is Miss Shriver because she didn't have possession of her phone, they wanted the call logs, they never got them. And there may have been a reason for that, I don't know, but they never got the call logs for the phone. But maybe there were those that thought if they didn't have the call logs, maybe they wouldn't be able to see certain things. Well, maybe to many chagrin, there's such things as search warrants and other where one can get these logs. And I go back to the 8th, because again, I want to explain why the people did what they did. The 8th at 6:10, 6 a.m., there is supposedly this communication to Mr. Moore that he should no longer have any contact. Problem was that could not have been true. And the reason it couldn't have been true and what the people saw is that after a call on the 7th, approximately for over an hour, well, for 83 minutes between Ms. Shiver and Mr. Moore. After that call, when it gets to the 8th, and remember, it's 6 a.m. is what the people are told. There was a call at 2:49 p.m. connected for 7 between Mr. Moore and Ms. Shiver. There was then an additional call at 3:29 p.m. that connected for 4 minutes between Mr. Moore and Ms. Shiver. Those are outgoing calls from Mr. Moore to her. At 3:41 p.m. on that day, there is an incoming call from her to him for 11 minutes. There is then at 7:41 p.m. an outgoing call for 27 minutes from Mr. Moore to Ms. Shiver. Here's what the people realized. the very foundation of the stalking charge, which would have been the telling not to contact me on the 8th. There is no call on the 8th. But the very foundation, it couldn't have happened. The people realized that when they got that information. Bottom line, by necessity, then, the stalking charge would fail. If the stalking charge fails, it being the predicate for the felony also had to fail. And the people knew this, and they did the right thing by making sure that that charge did not go forth.
That's arguably the biggest legal reveal of the entire hearing. The judge is saying the foundation of the more serious charges collapsed once additional phone records were reviewed. And notice the language: legally, morally, ethically. He's not just explaining the law, he's defending the prosecution's decision to change course. For anyone wondering why the original charges didn't stick, this is the answer.
Because in good faith, legally, morally, ethically, they could not proceed on that. And they knew it. They didn't try to hide the ball. They didn't try to do any of that. They didn't say, well, we're still going ahead. We're just going to put them through the paper. They didn't do any of that. They did the right thing. The third charge, which was the illegal entry to the premises, also had its problems. And I'm not going to go through sort of an extended analysis, but suffice it to say that Mr. Moore had access to those premises. That access was granted by Ms. Shiver. She gave him the code to the door. It wasn't just a key. He had the code to enter the premises. People, in analyzing it, said they weren't going to proceed on that either, because that was inconsistent with what was being told to them. Now, having said that, I hope that people can understand why this case ended up where it is. At that point, when I have to say from the defense side, there may have been those that would have just proceeded with the case, let it become back as a not guilty and try to be done with it, but that's not what they did. They realized that there were certain wrongs that had occurred. The parties came together, and there certainly between them were decisions on what charges would be appropriate. After reviewing everything so that people understand, it was reviewed by the prosecutor, got reviewed by the defense, and this court itself reviewed all of the reports. The right thing happened. The charges, the criminal charges that this defendant, Mr. Moore, would have been guilty of, he pled to. No more, no less. In any sentencing, it is important that the court consider a number of different factors. I look at the defendant. I look at the effect that seeing the defendant's conduct had on the victim in the case, in this case, Ms. Shiver. And in that, try to come to a resolution in my mind as to what would be an appropriate sentence. In this state, there are impact statements that are given so that the court can hear the victim and the victim's voice, the one that was wronged by the conduct, so that you could hear. I truly would have preferred to hear Ms. Shiver's voice much more clearly and much more directly. I regrettably, rightly or wrongly, legitimately or not, her voice for the court to hear has been clouded. But through my probation department and the like, I have a sense of what are concerns for Ms. Shiver. one of those concerns is that she won't be heard, and that the defendant will not be held accountable in any way. And it was interesting to me that there was communication to the court prior to the victim's impact statement that I was not aware of prior to receiving the communication that had occurred in this courtroom. I was not on the bench at the time, but where an individual who Ms. Shriver and her people believed were part of the court had gone up to Mr. Moore, shook his hand, and gave him a hug. I want to make it real clear so that it's the individual that did that was a member of the sheriff's office here, is not a member of the court, is in no way connected to me or this court, and that I was not even aware that I was not in the room. I actually had to go and see it online. That should never have occurred. Not because it didn't have or would have had an effect on this court. Shouldn't have occurred because of its appearance of occurrence.
Listen carefully to the shift in tone here. Up to this point, the judge has focused heavily on legal facts. Now he's turning to victim impact and accountability. Sentencing isn't only about what happened, it's also about the consequences that linger afterward. This is where emotion and law often collide in a courtroom.
But Shriver also asked for the strictest punishment that this court could give. Incarceration is usually left to those times where an individual, this court would continues to pose a risk to society or others, or that this court believes can't in some way conform themselves to the norms of how we should operate in society. I don't believe, as I look at the entirety of this case, that incarceration would be an appropriate sentence in this case. Now, having said that, should there be, and I think that a probationary sentence is appropriate, but should there be a violation? And I will send my direct warning to you, Mr. Moore, that should there be a violation, all bets are off today. I don't like sending people to jail, but I will not have a problem with it. As the prosecutors indicated, this court is very mindful that that day, December 10th, a number of things happened that changed people's lives. In imposing a probationary sentence, I would let Ms. Shriver know that this court is not by any means lessening the impact of those events. Frankly, Mr. Moore, you had no right to do what you did. I know that she was placed in fear. It was a traumatic experience that day for you. It was certainly a traumatic experience for her, but you had no right to spread your pain to her. And as I was going through this sentence, and there were a number of letters, a number of things presented to the court, and attempting to try to decide upon the appropriate sentence, there is a certain irony in a lot of this. And it's a big one, in my opinion. The person, quite frankly, Mr. Moore, that is saving you from the full wrath of this court is the one you betrayed. I don't know where your wife, Kelly, finds her strength when all of the circumstances are happening and they're happening to her and she's absorbing them in real time. She not once loses her focus. she not wants Bats and I to sort of doubt you. She not wants something terrible to happen. As I listened to the terror in her voice that day, I don't think there would be anybody in the world that, given all of the circumstances, would have blamed her if she just said, I don't care. It's not what she did. She didn't know where you were, but she was going to tell the police, try to do this to find him. She said something that was remarkable, and that is just tell him I love him and to come home. Incredible. And when you and you know, so I'm listening on one of the calls, listening to her. I can hear your babies in the background. She's what she had to deal with was just an incredible burden. She didn't bat an eye. The letter that she wrote to the court, and there were a number of them, and like I said, I went through all of them, certainly had the biggest impact on this court and what I should impose. I figure, certain ways, that she was just pointing forward, leaning on her faith, and trying to put her family and find a way forward for her family, which was inclusive of you. I think in life, sometimes people take a lot for granted. You, sir, take her for granted. I am amazed by you, Miss Moore. Truly am. I don't know where it comes from. I think, in all honesty, given all the hurt and pain, that if we had more people like you in the world, I may be out of a job, but I think this world would be a better place. So therefore, the sentence of the court as to count 4, that I'm going to place the defendant on an 18-month probationary term, months under the prosecutor deferred sentence. You are to pay $555 fines and court costs. We will take those court costs out of the bond. You are to pay $540 probation oversight fees. Those will also be taken from the bond. There is to be no use of any alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to continue mental health.
And there it is, the final sentence. No jail time beyond credit already served, but a lengthy probation term, mental health treatment requirements, strict no-contact provisions, and multiple behavioral restrictions. Some viewers will see this as accountability without incarceration. Others will think it wasn't enough. Which side are you on? Did the judge get this sentence right, or would you have gone further?
Treatment, follow all recommended care, the status reports to probation. You are to have no contact with Paige Shriver, directly or indirectly, to any third parties. You are not to refer to her on the internet. You are not to communicate her using any electronic device. Am I clear on that, sir? Sure. You are not to go to any residence or employment of Paige Shriver. There is to be no assaultive, threatening, or intimidating behavior. There's to be no possession of any weapons, firearms, ammunition, or anything fashioned to be a weapon. I'll schedule a review hearing that will be held April 14th. Actually, the date is going to change, is it not, Ms. Cabrera?
Yes, Your Honor, it will be October 13th, 2027.
October 13th, 2027, 9 a.m. They will order 180 days in jail. Credit for the 3 days you served. The balance is suspended. As to count 5 to trespassing, I will also place you on 18 months probationary term, 18 months under the prosecutor deferred sentence. You're to pay $250 fines and costs. That will be taken out of the bond. You are to comply with all terms as set forth and what I have enunciated in count 4. I will order 30 days in jail. Credit for 3 days. The balance is suspended. To the people, is there anything else from the people?
No, Your Honor, thank you.
Anything else from the defense?
No, you're on.
All right. Thank you very much. Good luck, everyone.